Professor Levinson.
First thing I want to do is to endorse basically every single word that Owen Fiss has just said. I think it's all too accurate and extremely troublesome. I have written a much longer paper than could possibly be given in 30 minutes, so I take solace in the fact that it will become my 5th publication in the Tulsa Law Review, and various of the arguments will be extended then. Let me explain the title, which is slightly different from the title in the program, as often happens as one writes papers after sending in titles. The current title is "To What Extent is Judicial Intervention Against Torture a Hollow Hope? Reflections on the Israeli and American Judicial Experience since 2001. That is, this paper devotes much more attention to what has happened in Israel following Justice Barak's justifiably noteworthy decision in 1999 with regard to interrogation practices there. It spends relatively less time on American judicial experiences since 2001, particularly with regard to torture, because I think that one of the things that is simply noteworthy is that American courts have been basically absolutely silent. I don't want to say completely and utterly silent, but certainly the Supreme Court of the United States has said nothing whatsoever that is relevant or useful to the debate about torture. There are some decisions, and Owen cites Boumediene, which may be relevant to habeas corpus, but as he points out altogether accurately, the Supreme Court, precisely by adopting a laundry list balancing test, invites endless litigation about whether any actual living and breathing person will ever experience the ostensible rule of law freedoms that are enunciated or defended by the court. But with regard to torture, the United States Supreme Court and most so-called inferior courts have had nothing useful to say. And here, in a sense, I do want to advert to my spontaneous intervention a few minutes ago with regard to kind of getting Marbury right. From William Marbury's perspective, the Supreme Court was a hollow hope. And this term is adopted, as many of you know, from Gerald Rosenberg's famous and justifiably controversial book, published about 20 years ago now, called Hollow Hope, in which he said that particularly political liberals put entirely too much faith in the ability of federal courts, and in particular the United States Supreme Court, to bring about great social transformations. It's not that they couldn't do anything at all, but as a matter of empirical fact, Rosenberg argued, they could do very little. And he took as his test cases what most political liberals view as high points of judicial, either call it activism or call it standing steadfast in behalf of what the Constitution truly means. From one perspective, it really doesn't matter what your view on that issue is. Brown versus Board of Education and Roe versus Wade, and Rosenberg argued that the actual consequences, the actual measurable consequences of those two decisions were far, far less than most law professors and lawyers, especially, who tend to have a vested interest in promoting the importance of the judiciary, that they were much less important than one might have hoped, particularly if you supported those two decisions. There has certainly been transformative change with regard to race in America, but what Rosenberg and others would argue is that the cause ultimately was the civil rights movement and, frankly, Lyndon Johnson's willingness to wreck the Democratic Party as it then existed by seeking his own redemption, helped along by the remarkable election of 1964 and the advantage of having a martyred president who could offer additional momentum to a civil rights bill that had been introduced by John Kennedy, though there's no reason to believe that Kennedy supported civil rights at all to the extent that Lyndon Johnson, who was in fact trying to overcome some demons of his own career. And maybe I'm reflecting that I live in Austin and see the Lyndon Johnson Library every day. But that is a remarkable story in American politics. But the argument is that Brown plays a relatively small role, and American politics, or for that matter, Harry Truman's remarkable willingness to desegregate the armed forces against the opposition of the Joint Chiefs of Staff in 1948, or Branch Rickey's willingness to bring Jackie Robinson to the major leagues in 1947, had as much to do with these transformative changes as Brown versus the Board of Education. Now, obviously people can debate about that, but this is the framework from which my title comes. But as I say, with regard to figuring out whether the Supreme Court has proved a hollow hope in Rosenberg's particular sense, that is, they accept a case, they render a decision, and then the question is, well, what really happens on the ground? Does desegregation occur in the states of the old Confederacy between 1954 and 1968? And the answer is by and large no. It is the Civil Rights Act and the involvement of the Department of Justice, in which Owen served, that bring about tangible measures. I graduated from Hendersonville High School in Western North Carolina in 1958, and I assure you it was as segregated a school in 1958, 4 years after Brown. I remember where I was on May 17th, 1954, and hearing my teacher saying, "This changes everything." Well, it didn't change anything at all in the next 4 years, even though Hendersonville High is now fully integrated, and one can debate about how much of it is because of courts and how much of it is because of legislation. But you can give the Supreme Court credit for at least trying. Ditto with regard to Roe versus Wade, if you in fact support the principle of reproductive choice as protected by the Constitution, as I do. But then, of course, as everyone knows, especially in a state like Oklahoma, there is a huge gap between the ostensible right of a woman to enjoy reproductive choice and the practical ability to enjoy that. And of course, the Supreme Court, whether or not it overruled Roe or not in Casey, at a formal level it didn't. In other levels, it certainly changed some of what had been thought to be the central meaning of Roe. But again, that's kind of irrelevant. This is not about Roe versus Wade, but rather the practical ability of courts to effectuate change that requires the voluntary consent of a lot of low visibility officials. Bush versus Gore is an anomaly because that required the assent of relatively few people, and rightly or wrongly they gave it. But it didn't require that low visibility bureaucrats had to do very much, except to regard George Bush as a legitimate president, which is no small matter. Whereas with regard to Brown or Roe versus Wade or criminal justice decisions, you really have to try to affect the behavior of lots of low visibility officials who may very well oppose the decisions. But I say at least the Supreme Court tried with regard to Brown and Roe, for better or worse. But there's been no effort at all with regard to the torture issue. And here, and I do go back, again invoking Marbury one last time, the importance of Marbury is the procedural mechanism by which the Supreme Court avoided tackling the Jefferson administration in a context where they knew the Jefferson administration was very likely not to comply. So from my perspective, John Marshall made up a thoroughly implausible reading of Section 13 of the Judiciary Act and Article 3 of the Constitution in order to get the case out of the court, which was a thoroughly political decision, my view is, and the politics are that the court was not willing to tackle an administration they viewed as in opposition, or perhaps a public opinion that might have been in opposition. I don't know exactly why the United States Supreme Court has been, and most federal courts, Owen invokes the District of Columbia Circuit, which is a very esteemed court, which has also refused to confront many of these issues by adopting state secret privileges or other sorts of national security privileges. So it seems to me that on the American side, the issue, alas, except for Boumediene, where you can engage in a kind of traditional political scientist inquiry of what difference does the Supreme Court decision make. And the evidence is still very much out for reasons that Owen indicates, whether Boumediene will be any more than a blip with regard to pronouncing any genuine transformation. But there are no decisions of the Supreme Court or of any circuit courts that talk seriously about methods of interrogation. And I want to bring up one other point with regard to what Owen said. Yes, it is true that on the first day of his term, President Obama announced that we will not torture. But in fact, George W. Bush never said we would torture. The whole point of the notorious U memorandum was to define what constitutes torture. Most of us believe that the U memorandum is a scandal, but it never once said that, yes, this is torture, we're going to do it because of overwhelming national security incidents. Rather, and this will become relevant in a few moments, John Yoo actually cited Aharon Barak's decision in the Israeli case precisely for the proposition that what was condemned with great eloquence in that opinion was described as not torture, but rather merely cruel, inhumane, and degrading. But of course, if you're a well-trained lawyer, these terms are important because the UN Convention says there are no circumstances whatsoever that justify torture. And it says, look, you say you're at war, you say there's a civil war, you say there are national security interests, doesn't matter. You can't torture. But the UN Convention does not say, at least from my reading, that you can never, ever engage in cruel, inhuman, or degrading methods of interrogation. It may require a super-duper compelling interest in the language of American constitutional law, but that's very different from saying that there are no circumstances whatsoever. So the U memorandum was very clever in its construction. And I say the Bush administration has never said, oh yes, we embrace torture. And you know, there's all of this debate about whether waterboarding constitutes torture. I think the answer is yes. But one of the things that Owen left out of his paper, perhaps because he prepared it 10 days ago rather than just in the last week, is that the Obama administration, to its disgrace, has fully embraced the treatment being visited right now on Bradley Manning, the alleged leaker in the WikiLeaks controversy, who is being kept under round-the-clock solitary confinement, deprived, practically speaking, of the ability to sleep very much at all. From my perspective, this is torture. Now, maybe it's merely cruel, inhuman, and degrading, but not only did the administration fire the State Department spokesman who said altogether correctly that this was a crazy thing to be doing to Mr. Manning. But this has been solemnly defended as for Mr. Manning's own good and not torture at all. So the devil is in the details. One of the things that Ona Hathaway, a colleague of Owen's at Yale, pointed out is that I think 130 countries signed the anti-torture convention. It's kind of a cheap gesture. The real problem is, first of all, compliance, but secondly, definitions of torture. And well before the Bush administration, the United States Senate, when it ratified the Torture Convention, put enough reservations in what counted as torture that at least the government of the Netherlands formally protested and said that this kind of had warped the UN Convention. Now, I don't think the UN Convention is really particularly illuminating either on what counts as torture, but it's more restrictive than the definition adopted by the United States Senate, I think largely thanks to Jesse Helms, who was head of the Senate Foreign Relations Committee at that point. There is a lot that unfortunately I will simply skip about current American events, because not only is it the case that the United States Supreme Court and district courts have said nothing illuminating, have not even tried to say anything illuminating. They have, like Marshall in Marbury, from my perspective, chosen a variety of procedural ways to avoid confronting these on the merits. But I also have a discussion, much of this paper is about the Yale Law School, treating on her own as a member of the Yale Law School. But Owen's colleague Bruce Ackerman has also written a recent book in which he bewails the decline of American politics and the loss of our our Republican form of government as in effect. And one of the very powerful points that Bruce makes that I agree with very, very strongly is that much of the relevant litigation, and I put that in scare quotes, occurs outside of the courts at all. It occurs within the Office of Legal Counsel, within the Justice Department, and increasingly also within a enhanced, I think Bruce would say, grotesquely enhanced White House counsel's office. So that, this is why the U memorandum is so important. I have no doubt that there is an OLC memorandum being prepared, perhaps even as we speak, to justify what Bruce and many other people view as very, very dicey unilateral intervention, unilateral decision by the president to intervene in Libya, where there is no serious argument the United States is under attack. Maybe the intervention is justified, but one might think that it would have been useful to get congressional consent. One might even believe that since it's an act of war to bomb a foreign country, if you're a really old-fashioned constitutionalist, you might even believe that Congress should have been asked to declare war on Libya and to have this explained. But of course, there is nothing of this going on. There's not going to be a court case. The Vietnam War was never the subject of litigation. We could bet the ranch, as we say in Texas and perhaps in Oklahoma, that the Supreme Court of the United States is not going to take a case and decide on the merits, but the OLC will write the opinion. The OLC is astonishingly unindependent. Now, I will say some of my best friends have served in the OLC, and I respect them tremendously. I think they're people of integrity, but the whole point of whether or not it's life tenure, I oppose life tenure of the kind we have in the United States. I think that a limited term, as in Israel and almost everywhere else in the world, is preferable. But the justification of life tenure or service until 70 is that it does promote independence. People serve in OLC basically at the pleasure of the president or the pleasure of the attorney general. And I think Bruce Ackerman is altogether correct to say that one of the conversations we ought to be having in this country is how to organize what in France would be called our system of administrative courts, which as a practical matter more and more makes central decisions. So I actually agree with the position of the Obama administration that it would be unfair to go after most, if not all, of the CIA interrogators. Abu Ghraib is a sideshow. The real torture debate has to do with the CIA and other professional interrogators. And I agree with Owen. I think it's a scandal that nobody is held accountable for anything of what occurred over the last 8 or 9 years. But I do also agree, and I would be happy to represent a CIA interrogator, that if you have an opinion written by the Office of Legal Counsel that says this doesn't constitute torture, or when very high issues of national security require enhanced interrogation, then it is constitutional, I would be very disturbed to say, well, you should have just ignored what the OLC has said, because at least in theory, these are a group of very, very distinguished lawyers who have taken the same oath that judges have taken to be faithful to the Constitution. And as I say, part of the problem with the John Yoo memo might be what it said, but another problem might be how did this young and inexperienced and ambitious and very smart and well-trained lawyer get to be in a position where he could make the law for not only the executive branch, but in essence for the United States, and then what ought to follow with other people. Okay, those are some comments about the United States, which will be elaborated further in the published version. I do want to say a few comments, which will also be elaborated at length in the published version, because the Israeli situation is much closer to raising the sorts of issues that Rosenberg and other legal sociologists are concerned with. That is, what happens after courts speak with great eloquence to a given issue. And here, I think, at least on the basis of what I have read, the evidence is very mixed. Joseph Lelyveld, the former executive editor of the New York Times, did an article in the Times magazine in 2006, just after, coincidentally, he had actually sat in on a couple of sessions of the course that I was giving at the Harvard Law School called Torture, Law, and Lawyers. And he went to Israel and interviewed a number of people. And at least according to Lelyveld, the results were quite mixed. That some people, in fact, said that it made a difference, that interrogation practices had, in fact, changed. But other people said, well, they hadn't changed as much as one might wish. So, in fact, let me quote from Lelyveld. After he quoted Ami Ayalon, former Israeli security chief, who promptly announced that his interrogators would obey the court, unquote. Then Lelyveld goes on to say, quote, this may sound like a happy ending, a triumph for the rule of law, but what actually changed? Not as much as the sweeping judicial edict seemed to promise, according to the Public Committee Against Torture in Israel, a human rights group that seeks to monitor what happens to detained Palestinians. The committee maintains that Ayalon's pledge to abide by the Supreme Court's decision was never wholly enforced and seriously broke down after the outbreak of the Second Intifada. Torture remains routine in Israeli detention centers, the committee contended, offering affidavits taken within the last year, that is 2004, from prisoners, and I won't go on to read the rest of the particular paragraph because of time. But what Lelyveld also says is that there was, he quotes Hannah Friedman, executive director of the Public Committee Against Torture, saying that her group had chosen quite consciously not to try to relitigate some of these issues before the Supreme Court for fear that it might provoke a decision that would weaken the legal standard that had been adopted in 1999, precisely because of the Intifada, and of course changes at Knesset, because one of the issues certainly that is left open in Justice Barak's opinion is the extent to which the Knesset basically could override the decision. It's a little bit, frankly, like Hamdan, where the Supreme Court said that the problem was that there was no authorization for what was being done. Lo and behold, within a year, thanks in part to Arlen Specter, who said, well, I think this is unconstitutional, but I'm going to vote for it anyway, a panicked Congress before the 2006 congressional elections gave the Bush administration the authorization to do this. And so there is always that fear the Supreme Court can speak, who will listen, but also to what extent is the decision of the Israeli Supreme Court truly final in the sense of being protected against override by the Knesset. I also note the release in 2009 of another report by the Public Committee Against Torture in Israel called Accountability Denied, the Absence of Investigation and Punishment of Torture in Israel, that comes to the conclusion that there has been put in place a complex administrative system that in fact tolerates a great deal of behavior that was properly denounced by the opinion, in part by either misreading. Now, we could get into an argument. Justice Barak very explicitly said that there is no ex ante approval of torture. One of the debates within this country is the debate provoked by Alan Dershowitz about so-called torture warrants. And Justice Barak's opinion very clearly indicated no torture warrants. But it did seem to indicate that there was a possibility of an ex post necessity defense. That is, the opinion did not adopt a truly strict liability perspective, that if you engaged in violation of the opinion, then off to jail you went. There would still be a possibility to invoke a necessity defense. And the argument is that this has inevitably transformed from an ex post sort of procedure into an ex ante procedure. One very last point, because I have gone a couple minutes beyond the allotted time. I have found in the time I have spent getting my mind dirty. Michael Walzer once wrote a great essay called Dirty Hands, and I think inevitably if you think about torture, you get your mind dirty in a variety of ways, not only confronting the particular actions that are done, but also trying to figure, well, are there circumstances in which they might be tolerable? And I found it useful as a thought experiment simply to ask people, say with regard to the 1999 decision, would they prefer a system of strict liability, that is, no defense at all for anyone accused, not simply of torture, because, again, the issue in the 1999 decision was not torture. It was cruel and inhuman and degrading methods of interrogation? Would you adopt strict liability with mandatory extended punishment, so that if you are shown to have engaged in this action, you are guilty because there is no defense, and you would go to jail for, say, 20 years with no possibility of parole? I mean, Americans love long mandatory punishment for drug offenses and the like. Though under the Rockefeller regime, you didn't need 3 strikes. 1 strike, and it was 15 years in jail. So, would that be a suitable response? And I'll simply report that I find very, very few people who would say, oh yes, any infliction of this presumptively illegitimate form of interrogation should, without any further discussion, lead to a 15 or 20-year jail term. I find that part of the reality of getting my own mind dirty with this, because I confess I wouldn't support a strict liability coupled with a 15 or 20-year jail sentence. And I think if you do adopt that perspective, you realize that the issue really is an unfortunately complex issue that doesn't reduce itself to a very quick and easy one-sentence resolution of the kind, I would say, that you find in Article 2 of the UN Convention, which, by saying no torture ever under any conceivable circumstances, simply encourages a very well-trained person like John Yoo to say, good news, this isn't torture, so it doesn't come under the non-defeasibility aspect of the UN Convention.